I hope you are all very well. Once again, thank you for joining us. It's lovely to be here. What I'd like to do today is talk to you about the Homes Act 2018, which covers fitness for human habitation. Now, before we start, I just want to say a few thank yous as always. So thank you to Marion. Lee mentioned that you got in touch with us, and that was lovely. So thank you very much for your kind words. I'm so glad and happy that these sessions are of really good use and value to you. And also thank you to Georgina for getting in touch as well. That's really kind, and I hope I can be of assistance, anytime as always. So let's get started. I'll share the screen with you. So here we go. Okay. So the Homes Act 2018, fitness for human habitation. Now, you may well have heard of this, but if you haven't, hopefully this will enlighten you today. Really, it's really simple, and I think a lot of this is carried out anyway in our general thoughts and processes with presenting a good property to our tenants and something that is safe and free from hazards. So here is some extra information for you. And these items will come up today in the webinar. So we've got Homes Fitness for Human Habitation Act. There's the link just here. Then we've got the Housing Act 2004, which is the second one. Then we have the Housing Health and Safety Rating System, HHSRS. And then finally, there's the additional guidance for landlords, which is a handy document to make sure you can get it right with your property. So, what is the Act? So the Homes Act 2018 says, the Homes Fitness for Human Habitation Act 2018, known as the Homes Act, replaces Section 8 of the Landlord and Tenant Act 1985 in England, with the purpose of improving living standards in the private and social rented sectors. So there's the emphasis. It's all about providing a safe and proper environment for your tenants so that they're happy and they're not going to come a cropper during the tenancy due to any negligence on our part. And I say our part, landlords and agents, because the law says we're both responsible for this. So we've got to work together. Now, there were some changes in 2018. Originally, we had the Housing Act 2004, and under the Housing Act 2004, landlords and agents weren't required to ensure that their rental properties were free of potentially harmful hazards. So what that meant was, consequently, an offence was only committed when the landlord or agent had failed to comply with an improvement notice issued by the local authority, which, when you say it, that sounds daft, doesn't it? The tenant couldn't take the landlord or agent directly to court in this case, and had to rely on the local authority. So what that meant was a landlord could legally rent out a defective property unless the local authority had told them otherwise in terms of rectifying those hazards, which, like I said, sounds absolutely crazy. So it needed updating, didn't it? Otherwise, that's very one-sided and somewhat unfair on our tenants. So here comes the Homes Act 2018. So under the Homes Act, landlords and agents have to ensure that the property, including the common parts as well, are fit for human habitation at the beginning of the tenancy, but also throughout the duration of the tenancy. Tenants are allowed to take direct legal action if we don't comply with this. And it doesn't need the local authority to pay a visit anymore. That doesn't need to happen. The tenant can just go direct to court. So does your tenancy fall under this legislation? Well, yeah, I guess it does, because what the Act said is that it covered all domestic tenancies that have been granted, so that's new, or renewed on or after the 20th of March 2019. And then this year, on the 20th of March, that included all periodic tenancies that started before the 20th of March 2019. So there's been activity on this very Act only a few months ago. And remember, this covers England only. And I just want to reiterate that. So if you have properties elsewhere, do please double check that your Homes Act is applicable and how it applies to your property if that's not in England. For those of you that like a bit of detail, the Homes Act amended Section 9 of the Landlord and Tenant Act. And really, in summary, the main point that that covered was originally it just covered houses, but now it includes all dwellings. So flats, maisonettes, they are now all included within the Act. So that covers pretty much all domestic properties. What it doesn't cover is a license to occupy. This includes lodgers and those living in temporary accommodation, for example. So if you do have lodgers, you don't need to worry so much regarding the Homes Act. Now, the fitness for human habitation, I mean, what is it? We've mentioned this a couple of times now. It is defined within the Landlord and Tenant Act. And like we said, the Homes Act amended this to include all dwellings as well as houses. But what really makes a property fit or unfit? Now, a property that is unfit for human habitation is so far defective in one or more of those matters that it is not reasonably suitable for occupation in that condition. So these matters that it refers to, one or more of these matters, this is a list or a criteria, if you like, that was set out in the Landlord and Tenant Act. So let's have a look at these. They are pretty obvious, to be honest with you, but it covers repair at the property, stability of the property, freedom from damp, internal arrangements, natural lighting, facilities and preparation for cooking of food, water supply, drainage and sanitary conveniences, ventilation, and facilities for the disposal of wastewater. Now, I think all of those are pretty reasonable, don't you? And I'm pretty sure that all of these are covered in terms of the properties that we deal with, and that they're all safe, they're stable, there's all the necessary sanitary equipment, because it's a modern time that we live in. But this all still needs to be adhered to. Now, what the Homes Act added to this list was a list of what they call any prescribed hazards. So coming back to the original Housing Act 2004, now, what is a hazard? They define a hazard as any risk of harm to the health or safety of an actual occupier of a dwelling, or HMO, which arises from a deficiency in the dwelling, or HMO. Now, HMO, for those of you that aren't sure, is a house of multiple occupancy, where you have a number of tenants that share facilities but are technically all separate and from different households, as they call it. That isn't another subject entirely, but that's just for your reference, the HMO. So what are the prescribed hazards? The prescribed hazards are given to us in the document called the Housing Health and Safety Rating System that we mentioned a little bit earlier at the start of the webinar, the HHSRS as its name. This has 29 and no less items of criteria that we need to look at when renting out a property. So I'll just give you a second or two just to have a scan through those 29 items. You can count them if you want. There are 29, I promise. And yeah, just digest some of those for a second. Now, I hope some of those are pretty obvious again, and there might be some that don't immediately spring to mind when you think about the safety of your property. You know, one example there that occurred not so long ago, I think it was last summer, we had a family moving into a home, lovely home, nice modern home, and they had a little boy, I think he was about 3 years old, and it revolved around the falls associated with stairs and ramps. And this house it was a lovely modern house, and it just didn't have banisters on the stairs. There was about 3 or 4 stairs going up, and there was no banister. So there was a couple of feet where a little boy could potentially crawl across, climb across, injure himself. Anyway, we spoke to the landlord about this, and the landlord very sensibly, got a contractor in and installed a banister with a lovely sort of see-through screen, which really complemented the property. The tenant was absolutely, over the moon. It looked great. Landlord was really happy, and I think those tenants are still at the property and are about to renew, I think. So that's a reason why we need to do this, not only for safety, but if your tenant's happy and they're living in a comfortable environment and they're not worried, the chances are they're going to stay a bit longer at your property. So what do we need to do? We know what the hazards are. We know that we can check our properties, but what really do we need to do, and what does the legislation require from us? So we are aware that through a implied covenant, the Act does place responsibility on us to ensure that the properties are fit. And like we said earlier, it's at the commencement of tenancy, but also for its duration. So before the tenancy, we've got to make sure that any hazard that is identified is remedied before the tenancy starts, okay? You really don't want a tenant walking into a property, spotting a problem straight away before they've even moved their furniture in, and that tenancy starts on a bit of a sour footing. You want to try and avoid that. And also, with the thought that a tenant could take you to court, it's a really good idea to make sure your property is in tip-top condition. So what the Homes Act also did, though, was remove the requirement for the FFHH, Fitness for Human Habitation, to apply to potential occupants, where previously someone who wanted to rent the flat said, well, I'm not going to make an offer or make an agreement with you until you can show me that the property is free from hazards. That was sort of, that responsibility was taken out because the wording stated that it applied at the start and during the tenancy only. So as long as it's all in good order when the tenancy starts, that's fine, and nothing would need to be done prior to that. So what about during the tenancy? So really, obviously, as we know, the tenant would notify the landlord or the agent if they've identified a hazard. What we would do with our managed properties is a property manager or a contractor would go to the property in the first instance and take a look and investigate and confirm what this hazard is, and indeed if it is an actual hazard, and of course the action that would need to be taken. A good way to avoid having an upset tenant is to take preventative measures, and that's really simple. Property visits, property inspections. Again, if you're one of our managed properties, we will do periodic inspections to make sure that the property is in good order, identify any hazards before they become a problem. So in doing so, obviously 24 hours notice has got to be given for any inspections, as we all know, but also for any repairs as well. And remember, it's not just the property, it's the communal areas as well that we need to be thinking about during the tenancy. Now, the only slight spanner in the works here is if you can't get access. Now, it would be very counterproductive for a tenant to cite a hazard, but then not allow access. It doesn't sound very sensible to me. However, I guess it's happened a number of times, which is why the Act actually has to cover it. So in that case, we can seek some legal advice, but the main thing is keep a solid record of all attempts to contact the tenant to try and rectify the issue. And of course, dates, times, and everything like that need to be kept so that we can show we've done everything possible. So that's before the tenancy and during the tenancy. So what about rectifying the problems? What's the best way to do that? So once the tenant has notified us of the issue, then there is a responsibility to have that hazard remedied in a reasonable amount of time. Okay. Now, what is a reasonable amount of time? I guess that is determined by the actual hazard itself. What is the severity of the hazard? Is there an immediate danger? Would a few days be sensible? Would 24 hours be sensible? take it on a case-by-case basis. But of course, we've got to seek to rectify the hazards as soon as possible. And in doing so, as I always advise, keep your documents, retain those documents for any repairs or maintenance that has been carried out before and during the tenancy. Just keep that all in your property file should you ever need to call on it, okay? Now, if we've been made aware of the hazard, but we're not actively trying to remedy it, which wouldn't happen, I can guarantee that, then obviously if it did happen, the tenant would have the right to take us to court. It would be up to the courts to decide then what the reasonable timescale is and whether us as agents or you as landlord have actually carried out our duties within that time. And of course, if you have carried out works during the tenancy, and of course, if a tenant has reported a hazard to you, it's a really good idea, once that has been taken care of, to send a report to that tenant. Most tradespeople and contractors will provide a report of the work they've carried out. So it's always a good idea to provide that to the tenant because it provides total transparency and hopefully peace of mind for the tenant as well. Now, there are, in some cases, there are going to be exemptions. So it's not the case that the tenant calls with any issue whatsoever and you've got to jump on it, otherwise they can take you to court. It's not quite like that. There are a number of potential situations that occur where it's probably not going to be our responsibility, i.e. you as landlord or myself as agent. So let's have a look. So the property not being looked after in a tenant-like manner. Now, if the unfitness of the property has occurred due to the tenant not using the home in a tenant-like manner, it could be that it's not the landlord's responsibility. Now, behaving in a tenant-like manner could cover a number of items that are detailed within the tenancy agreement. Things like unblocking the sinks or changing light bulbs, putting batteries in smoke alarms and carbon monoxide detectors, or, I don't know, keeping the garden in generally good order. The example that we can see here is a tenant purposely blocks air vents in the bathroom, resulting in damp and mold. So yeah, they're not acting in a tenant-like manner because they're not ventilating the property correctly as per the tenancy agreement. There is a clause that specifically says about ventilation in the property within our ASTs to cover this. On that basis, the landlord would not be liable. That is the tenant's issue. However, what we would do if we manage the property, we would write a letter to the tenant citing the clauses in the agreement and gently explaining to them what they need to do and give them the advice that they need to prevent this in the future. Here's another one along the lines of, you know, the tenant theme, which is the tenant's own belongings. So if the unfitness is due to a movable item that's been bought in by the tenant themselves, then there probably isn't going to be a liability to the landlord. So the example here is a microwave owned by the tenant that has exposed metal on the interior, which we all know is dangerous for a number of reasons with microwaves. But essentially, the fire hazard element is where the hazard is here. But this is the tenant's property. It's not yours as a landlord. So this is a tenant responsibility. It's totally down to them to look after that microwave if they have brought it into the property. I know these sound obvious, but I think they're important because I'm sure that, you know, there are calls that are received by you guys as landlords where a tenant says, oh, this isn't right, that's not right, and this isn't working, you know, and sometimes you just feel obliged to get it fixed, but do have a little think beforehand because, you know, it should be a level playing field for tenants and landlords. If you're doing everything right, then there shouldn't be a problem, but do double check things before you go ahead and spend money on rectifying things that could be the responsibility of the tenant. If you're unsure, talk to us and we can advise you accordingly. There are a couple more here that are slightly more unusual. So a landlord breach of obligations. And what this means is you could be exempt from carrying out works at the property if remedying the hazard breaches an obligation to another piece of legislation elsewhere, such as a listed building. Now, if you carried out work, you could breach the listed building's consent that you have when you own a listed building. And that would be a criminal offence to do that. So that obviously means that you can't go ahead and do the work, and therefore you would not be liable. And that could well apply to many properties within London. You know, the Victorian, Edwardian, whatever they may be. If you're in a conservation area, do double check, because you know you don't want to carry out works that are going to be a problem. And then this one, third-party consent, which I think might be a bit more common than the landlord breach, but this is where you need consent to remedy the hazard, but you can't obtain it, you can't get the permission. So say, for example, it's a leasehold flat, and you have to ask the freeholder or the superior landlord to fix the tiles on the roof, but that particular freeholder is absent, or there's no managing agent. So you can't really do anything, because you would be breaking and breaching your agreement. So as long as you've made every effort to contact the freeholder or superior landlord, and you've recorded that and made every effort within your power to rectify things and contact that person or that body, then you should be okay, and you're not liable for those works. So if you are a leaseholder, I would probably check that you do have a freeholder who's contactable, or you do have a managing agent that's responsible for it, to avoid these situations. And then finally, there is just one more, which is a county court exclusion. And this is simply where a county court has given exemption for one reason or another. And it's just as simple as a tenant has reported a hazard that's already been raised by a previous tenant and has been addressed and has already received an exemption from a county court. Okay, I've never come across this myself in the years that I've been doing the job. However, I just wanted to make you aware. So finally, if we don't do what we're supposed to do, of course, there is enforcement behind this, and there may well be a penalty. So where we fail to rectify a hazard, the tenant will take us to court. And it's from there that the court will identify what the issue is and whether or not the rules have been adhered to. So failure to remedy a hazard will result in grounds for unfit for human habitation. Now, the courts could say one of two things, or both. The agent and landlord must make that property fit and rectify the problem, and or the agent and landlord must pay compensation to the tenant. So there is no cap on this figure. So depending on the severity of the hazard, it may be a very small penalty, or we could be looking at maybe a couple of £1,000. That is up to the court to decide. Not only that, the local authority could get involved, because where the tenant seeks redress under the Act through the court, after that, the local authority would probably be interested to take a look, because they do have the powers to tackle poor practice from landlords and agents, you know, especially where necessary repairs are not being carried out. So you don't want to end up with an improvement notice, because that's not great, but also in the very severe cases, that you could find yourself on the rogue landlord list, which I can't imagine would happen with any of our tenancies. But I do remember my days working up in Camden. This was probably 2004, 2005, around that time. And yeah, I've seen some pretty horrendous properties that we wouldn't even deal with, and had a stern word with landlords about what they should be doing. But obviously until 2018, there was no real enforcement on this in getting the landlords to do it. But obviously the landscape in which we live in now is far more practical. It's a lot fairer. And I think it's going to continue going that way for tenants and landlords, because it's really important, you know, and as agents, we need to back this up, we need to support it and do what we need to do. So I hope today's been informative for you, and you've enjoyed it. I hope you've learned something as well. I know a lot of this has been very simple, and almost obvious, and we do it as a matter of the process of renting a home. But if you do have some questions, or if you want to ask anything about the 29 items on the list, then feel free to get in touch with myself. There are my details, or give your office a call, speak to one of your managers or to your property managers as well. So there we have it. Thank you for joining us today. I will be heading back to the office very shortly to go and look after the team. Now, what we're going to be doing moving forward is webinars now will be on a 2-weekly basis. So I won't get to see you all for another couple of weeks, but we will be returning and we'll be talking about client money protection, which is a really important subject. And again, earlier this year, further legislation was brought in, and it covers all agents really, and it's for your safety as well, the safety of monies and also the tenants. So that's what we'll be doing. So next webinar is 2 weeks from now, but Deborah will send you reminders and allow you to register for those as we get nearer the time. So I hope that's all right with you guys. We'll have to wait a couple of weeks before we get to meet up again. Now, I just wanted to let you know that there's been some great stuff going on recently over the last few weeks. There is lots and lots of activity in the lettings market, and also in sales. You know, the guys in sales are having a really positive time, and lettings is really thriving at the moment. Of course, there's been some pent-up business that we've had to deal with, but things are really flowing nicely at the moment. There's lots of agreements being made, and the team are really getting on with it. You know, at the moment, there's a big demand for outside space for people that are wanting to move, which I guess from lockdown is something that people are really craving. And should there be a second round of coronavirus, which I really hope there isn't, fingers crossed that we'll all be okay on that front, you know, people do want the outside space. So that's an interesting statistic that's coming out of what we're seeing at the moment. And demand levels, I'm pleased to say, are in excess of this time last year. So there's some really positive stuff going on there. So I just want to finish leaving you guys knowing that there is a good market there. So if your properties are coming back to the market anytime soon, don't worry. There is really good activity there. And I think this summer things are going to be slightly different, where there aren't going to be so many families going away on holiday. They're going to be staying in the UK for obvious reasons, and that could stimulate a lot of movement, especially, I guess, in the school holidays. I know it's kind of a funny situation for schools at the moment, but certainly that July, August, September period, I think could be a very busy period. And once again, I'm really proud of our team, the changes they've had to make to not only how they work and the processes, but also their lifestyles temporarily. Where we're running a shift system, we have the guys coming in 9 till 3, and then they swap over, and we have guys working from 3 till 9, and they've had to change their lifestyles completely. And it does throw us a bit, but I'm so proud of what they've done. You know, the video viewings process is fantastic, and they've really taken to that to make sure that we can do the deals and support you as our landlords, because without you, we don't have a business. And without a team, we can't perform, and I can't deliver all the good things that we do for you. So I just wanted to leave you on that note, because there's some good stuff happening out there. Okay. Anyway, I will see you all very soon in 2 weeks' time. If you do need me, just get in touch. I'll be happy to help. See you all soon. Bye.